He's not kidding. This is the law. It's about an inch thick of fine print. So I'm going to just give an overview. If people can hear me, I'll sit. Otherwise, I'll stand at the podium. So I'm just giving the overview. I'm not addressing for or against. So just a little bit of background. There's several cases that led to the enactment of the concealed carry law. The first is Moore versus Madigan, decided in December 2012. It's a Seventh Circuit U.S. Court of Appeals case. And it held that the unlawful use of weapons statute regarding firearms was unconstitutional based on the Second Amendment right to keep and bear arms. Now, that case started out actually as two cases that were consolidated for purposes of the appeal. A woman by the name of Mary Shepard, who was a member of the Illinois State Rifle Association, back in 2009 was volunteering as a treasurer at her church. And while she was doing that, she was assaulted and beaten by an intruder, along with an 83-year-old coworker. So in 2011, she, along with the Second Amendment Foundation, filed a lawsuit in the U.S. District Court in the Southern District of Illinois. And she sought an injunction and declaratory relief, saying Illinois cannot enforce these statutes because of the Second Amendment. In May of 2011, additional plaintiffs in Moore versus Madigan filed suit, and Shepard v. Madigan and Moore v. Madigan were consolidated for the appeal. Now, in March of 2012, the U.S. District Court dismissed the complaint, saying that the law did not violate the Constitution. And so it went up to the Seventh Circuit Court of Appeals. There was a 2-1 decision, with Judge Williams dissenting, Judge Posner writing for the majority, which reversed both district court decisions and orders in both cases. That court held that the laws were in fact unconstitutional and issued an order for remanding back to the district court to find the statutes unconstitutional and issue permanent injunctions. However, the Court of Appeals realized that this would wreak havoc in Illinois and its gun laws. And so they stayed the issuing of the injunctions for 180 days to allow the Illinois legislature to pass legislation that would pass constitutional muster. So that's Moore v. Madigan and how it came about. Another important case is People v. Aguilar. Alberto Aguilar was found guilty of aggravated unlawful use of weapons at trial, and he appealed. The state appellate court affirmed his conviction with 1 dissent. And so he appealed again to the Illinois Supreme Court. The Illinois Supreme Court discussed a number of cases in reaching its decision. They discussed the District of Columbia versus Heller and McDonald versus City of Chicago, both U.S. Supreme Court cases. One banning a law that held handgun possession in the home was unconstitutional. That's the Heller case. And the McDonald case, saying that Heller applied to the states through the due process clause, and it reiterated the self-defense right in discussing the Second Amendment. It also discussed the Moore case, and it also discussed a series of appellate cases that had held the law constitutional. However, in Aguilar, the Illinois Supreme Court agreed with the Moore reasoning and reversed the conviction and held the statute unconstitutional as a violation of Second Amendment rights. So now the legislature had the ball in their court, and they had to do something. So they put together House Bill 183, which is the concealed carry law that we're discussing tonight. Now, in putting that law together, they came to an agreement. However, the governor did not agree with that law. He wanted to make amendments to it, and he proposed those amendments. However, the legislature overrode his amendatory veto, and the law became the law of the land without the governor's amendments. So what kinds of firearms are we talking about? The law provides that a concealed firearm means a loaded or unloaded handgun carried on or about a person completely or mostly concealed from view of the public, or on or about a person within a vehicle. So what does handgun mean? Because all of this is driven by statutory definitions. A handgun means any device which is designed to expel a projectile or projectiles by the action of an explosion, expansion of gas, or escape of gas that is designed to be held and fired by the use of a single hand. And that's kind of the key language. It has to be a single hand. As you read through these definitions, you can tell that lawyers wrote them. So, what does all that mean? What kind of firearms are covered, and what kinds of firearms are not covered? So, what it does not include is a stun gun or a taser, because that is not a weapon that uses an explosion or gas to expel a projectile. It does not include a machine gun. I'm not sure how you would possibly conceal a machine gun on or about your person. I suppose maybe you could try in your vehicle. But a machine gun is not included. Nor is a short-barreled rifle or shotgun. Because as you probably are aware, sometimes shotguns, barrels are sawed off to make them more easily manipulated. And then pneumatic guns, spring guns, paintball guns, various other types of guns are excluded. Now, we hear a lot in the news about assault rifles and how they're used in mass killings. So assault rifles would not be included because it's not a handgun. Now, the concealed carry licensing provides for a 5-year concealed carry permit. So it's good for 5 years. It's issued to Illinois residents at least 21 years of age with a valid firearm owner's identification card, or commonly called a FOID card. It's to be issued 90 days after the application is submitted, with an additional 30 days allowed if you do not include fingerprints with your application. Carry licenses or permits from other states are not recognized. So if you come to Illinois with an Indiana concealed carry permit, that's not going to do it. You're not going to be allowed to carry a concealed weapon in Illinois. What you have to do is get a non-resident concealed carry license. That costs an additional fee, and we'll talk about fees a little bit later. And you can only get it if the out-of-applicant state concealed carry license law is substantially similar to Illinois' concealed carry license law. And that determination is at least initially made by the Illinois State Police. So lawyers are going to love this because it has language like substantially similar. That's language we're going to end up litigating. It's going to keep us in jobs. So you have to be age 21, essentially the drinking age. So that's kind of the gist of what it provides. So what are the license qualifications? We've mentioned a couple of them. You have to be 21, you have to have a FOID card or meet the requirements for one. The other thing is your criminal background. You cannot have been convicted or found guilty, Illinois or any other state, of 2 or more violations related to driving under the influence of alcohol, other drugs, intoxicating compounds. So basically, no DUIs in the last 5 years. You may not have been convicted of a misdemeanor involving the use or threat of physical force or violence to any person within the last 5 years. So you can't have basically a driving, alcohol, drug-related offense and a misdemeanor involving the use of threat of physical force or violence within the last 5 years. And these are convictions. There's another provision that discusses arrest, which we'll get to. So the misdemeanors have to involve the use of threat of physical force or violence. So those would be things like aggravated battery, domestic battery, menacing, those kind of things. You know, if you have a misdemeanor conviction for retail theft, that's not going to prevent you from being qualified for a concealed carry license under that provision. In addition, you cannot be the subject of a pending arrest warrant, prosecution, or proceeding for an offense or action that could lead to disqualification. So if you have a battery charge pending, and you've had another misdemeanor related to violence in the last 5 years, that's going to disqualify you, because that's a pending prosecution that could lead to your disqualification if you're convicted. You cannot have been in residential or court-ordered treatment for alcoholism, alcohol detoxification, or drug treatment within the last 5 years. And the reasoning, I think, behind that, not having read the actual legislative history, is the legislature did not want people with serious alcohol problems or drug problems to have a concealed carry license. And generally, if you've got a serious problem, you're going to end up in residential treatment. So if you're in outpatient treatment, that's fine. Because generally, people with less serious drug or alcohol issues get sent to outpatient treatment. I have a feeling if any Hollywood celebrities come to Illinois, they're going to have problems with that. You also have to have completed firearms training and education, and we'll talk about that component a little bit later. There is a provision that law enforcement may object to the issuance of a license even though you are otherwise qualified. So you meet all these other qualifications we've talked about. If law enforcement believes they have a reasonable suspicion that the applicant presents a danger to themselves or others or is a threat to public safety. So this is another one of those provisions that lawyers are going to love to litigate. What's a reasonable suspicion? What's a threat to public safety? So this might come in play, for example, if you are otherwise qualified, but you've recently been diagnosed and treated for some mental illness issue. And so maybe law enforcement gets wind of that and they send that information in to the state police, and they make an objection because they don't feel you're mentally stable enough to have a concealed carry license. And we'll talk about the Concealed Carry License Board in a little more detail. So none of this is free, of course. We are in the state of Illinois. The fees are payable to the Illinois State Police, because they're the entity handling all these applications. For a new license, it's $150 if you're an Illinois resident. If you're renewing, it's also $150. If you lose it and need to replace it, or if it's stolen, or if you're changing your address, it costs $75 to replace it. If you're a non-resident, you're seeking the non-resident license that we talked about because your state has a substantially similar concealed carry law as Illinois, then it's going to cost you $300. You may be subjected to fingerprinting. There may be an additional fee for that, but it does avoid delaying the process. If you don't submit fingerprints, as I mentioned, they can tack on another 30 days to process your application. So we talked about you have to go through firearm training. You have to have 16 hours of firearm training, and that has to cover firearm safety, principles of marksmanship, care and cleaning of firearms, and I think very importantly, instructions on lawful and appropriate interaction with law enforcement while carrying or transporting a firearm. Now, why do they require all this? Some of it is just basic firearm safety. You don't point a loaded gun at somebody unless you intend to harm them. Care and cleaning. We read in the newspaper or hear on the news all the time that people shoot themselves when they're cleaning their weapon, probably because they haven't been properly trained on how to do that. And interaction with law enforcement. The last thing we want to do is have someone with a concealed carry license who's carrying a loaded weapon get into a dispute with law enforcement, and we end up with a shootout. So they will be trained on how to properly interact with law enforcement to avoid that. The law requires live fire exercise of at least 30 rounds fired at a B-27 target with specified distances of 70% accuracy. Now, I don't know about you, but I don't know a whole lot about firearms training. So I had no idea what a B-27 target is. So I looked it up. So you can just pass these around. They're the kind of targets you see on CSI and NCIS and all those cop shows. It has to be 24 by 45 in dimensions. That's the little one.
So that's inches? Yeah,
inches. It'd be nice if it was feet. That'd make you a hell of a marksman.
That's life size, basically.
Now, you can receive credit for up to 8 hours if you've had hunter safety training or training in the military and you're honorably discharged. If you're at the end of 5 years, you're renewing your application, then you require 3 hours of training, including firing range. Now, the licensing board is made up of 7 members appointed by the governor. No more than 4 can come from the same political party. 3 come from Cook County, the 1st appellate district, and 1 each from the other 4 appellate districts. Illinois is divided into 5 appellate districts. We are in the 2nd appellate district, which is comprised of Winnebago and Boone counties. Now, there are certain places that you cannot carry a firearm. And there's a whole list of them here. You can go through them on the handout if you've got one. But generally, they're places where children are located, or large numbers of people are congregated, or they serve a lot of alcohol. We don't want alcohol and guns mixing. So it includes places like schools, colleges, universities. This past August, NIU, in fact, just updated their policy on guns on campuses and university property. And they have a no-gun policy. So we had a debate at the Georgia Legal Clinic of whether we were covered under the definition. We decided we are. So there's the rest of the list. I know I'm out of time, so just very quickly, Private property owners can post their property and not allow concealed carry on their property. And there's a website there put up by the state police which frequently asks questions. It's very good. If you want to post your sign, there is a template on the state police website. I printed off a copy. You can pass that around. So that's about an inch worth of fine print legislature in 20 minutes.